Good morning, live from ZTN Studios in Harare, Zimbabwe. Welcome to a discussion on Constitutional Amendment Number 2 Bill. Hello, I'm Andy Hodges. This broadcast is brought to you by Zimpaper's TV network ZTN and our partners, the Southern Africa Parliamentary Support Trust, SAPS, and the European Union. Now, should you have any comments or views on our show this morning, please contact us via our Facebook page, Zimpaper's TV network, or via our Twitter handle @ZTN News. The Constitution of Zimbabwe Amendment Number 2 Bill was gazetted on the 17th of January 2020. In today's program, we ask, what exactly is in this bill and what is contained in it? Why was it done now? Was there effective citizen participation in interrogating the contents of the bill? And what recommendations will civil society give for inclusion in the bill before it is passed by the Parliament of Zimbabwe? Now, today, to help us interrogate and explain Zimbabwe's Constitutional Amendment Number 2 Bill report, prepared by the Justice, Legal and Parliamentary Affairs Committee, paying particular attention to the amendments covering women, youth, running mates and the Supreme Court, we are joined in the studio by Philip Muziri, he's Southern Africa Parliamentary Support Trust SAPS Programs Advisor, MacDonald Munyoro, Programs Manager, the National Association of Youth Organizations, NAYO, and Sipati Moyo, she's the Chairperson, Politics and Decision-Making Cluster at the Women's Coalition of Zimbabwe, WICOZ. Ladies and gentlemen, welcome to the program.
Thank you. Good morning.
Right, so Philip, I always like to start with a basis, and of course my first question is, what exactly is the Constitution of Zimbabwe Amendment Number 2 Bill? What is in it, and why should it matter to Zimbabwean citizens?
Thank you very much, and good morning, Zimbabwe, and other viewers from around the world. This is the second amendment to the Constitution that was adopted in 2013. And it is important in this sense that it alters what the people of Zimbabwe agreed upon in 2013. So it is important for everyone to consider the amendments in detail in terms of whether they remain within the spirit of the Constitution that was adopted in 2013. What is contained in this particular bill includes the following. It will alter the way that vice presidents are elected into office, and it will also amend issues around how many ministers the president can appoint from outside of parliament. The bill will also alter issues around the women's caucus as we know it, the women's quota, as well as the youth quota, which was not in existence. It has provisions around these issues. The bill will also seek to alter issues around delimitation. There was a provision on delimitation of electoral boundaries. Further, it has also provisions around the judiciary, the appointment and elevation of judges from the High Court to superior courts. In addition to that, it will also alter the title of the civil service. It will also change issues around the chief secretary. In the past, the chief secretary was not a constitutional appointment. It will also deal with issues of public complaints against administrative malpractice by creating a new office. The bill will also alter the way that the prosecutor general is appointed and removed from office. It will also deal with issues around devolution of office, of state power from the center to the periphery. It will also deal with issues around international agreements. In today's program, I think we'll only focus on the women's quota, issues around the judiciary, issues around the running mate system, around the vice presidents, and also the youth quota. But by and large, it's a critical amendment to the Constitution of 2013.
I mean, Philip, 23 amendments. I mean, this is basically 23 clauses that are looking for amendments. And critics allege that although Zimbabwe's current constitution was adopted only recently in 2013, I can call it recently, many issues still remain outstanding. And I think the principal one is alignment or realignment of laws to the Constitution. So do you think that the amendment is necessary now, even before some of these existing Constitution, the existing Constitution has been implemented, or even some of the laws have been harmonized?
Well, the minister in his second reading speech mentioned that although it appears there are over 20 amendments, the actual amendments are just a handful. The rest of the proposed amendments, he said, are only consequential to the substantive changes that the executive are bringing in. But in terms of alignment, if you go through the committee's report, you find that the committee emphasized the need for alignment of legislation to the Constitution, because the Constitution is the fundamental law. But what this constitutional amendment does is to seek to change the Constitution even before some of the clauses that are being amended have been implemented. And in a lot of jurisdictions, the Constitution is treated as a document that you do not want to be altering at every turn. It's a fundamental document.
It's a sacrosanct document. In some countries don't alter it for 200 years even. I think America's a good example.
Oh yeah, that's the general approach to constitutional amendments. And to just point at one of these the amendments contained in this bill, you look at the proposal to amend issues around delimitation. There was an intention to alter the Constitution in order to align with existing legislation, when in fact it should be existing legislation that should be aligned to the Constitution. So I think we need to relook how we treat our own Constitution.
Now, thank you for that. Now, let's look at the issue. MacDonald, NIO is a youth umbrella body for youth organizations working in Zimbabwe. Now, if I look at Clause 11, Section 3.4.6 in the report, it states, and I quote, "It was also submitted that other alternatives to facilitate youth participation in politics can be done by ensuring that party lists on a national level include a significant number of youths. Therefore, the inclusion of youths could easily be achieved by requiring political parties to reserve a certain number of seats for youths." Is this something that your organization supports? And do you actually see this working in practice?
All right, I think for us as young people, having us being represented and included through the political party list system, for us is not it's not the panacea to the kind of challenges that young people face when it comes to issues of inclusion and direct representation in issues of governance and politics. We strongly feel that, I mean, for example, if you look at the political party system, it's the party that nominates the young person who gets to sit in parliament. And the question to us as young people is it going to be the youth wing of that political party selecting that young person, or is it going to be the main wing? And I'm sure we all know the internal dynamics of political parties. In most instances, they are the main wings that get to decide for us. And if we try to reflect and look at how the quota has worked for women representation since 2013, you'd find that there are a lot of gaps and issues that have also come with that. So I think when we reflect on that as young people, we acknowledge that in a way we spoke and the parliament listened to us. But then I think moving forward in terms of our inclusion and representation, we strongly feel that there is more that needs to be done and that needs to be given to young people beyond the political party system.
I mean, one of the issues that strikes me is that even if you have a quota of youth being elected to parliament, you know, how effective are you going to be when you get into parliament? Because obviously you're a minority, however you're selected. How can you express your views? Do you get, so to speak, swallowed up by the bigger issues and really not then are in parliament to focus on youth issues? So it's just putting more like younger people into parliament without really having the nitty-gritties behind it.
I mean, imagine yourself sitting in parliament and you don't represent a constituency. Who are you there to represent and to speak for? And we are saying that as young people, we need a fair chance and a level playing ground in terms of knowing the interplay and dynamics of governance issues. I should sit in parliament, I should represent a constituency. But also beyond that, in some of the submissions that we've also made, we've even critiqued, you know, the efficacy of having 10 young people in parliament. I mean, look at the numbers of young people. We are like 67.7% of the population in Zimbabwe, and just 10 of us in parliament. How are they even going to pick those 10? And also more critically, if you look at the 2013, the last 2018 elections, most of the young people that participated, that stood up for public office, were independent candidates. They were not within political parties. And that's a message to young people to say that within the political party system, there are a lot of challenges and stumbling blocks that close the way for young people. And we are now seeking the alternative, and the alternative is to run independent. And I think that might be something that we might actually need to look into as a country.
Because that also, well, I'll move to Sipati now, but that also makes it difficult to get elected because independents don't generally, against the two major parties, don't really get elected, I've noticed, yeah.
Yes,
I think only one independent, Tema Moliswa, got last time, so I can imagine how hard it is. Sipati, let's move to you now. The Women's Coalition of Zimbabwe, WeCause, is a national membership-based network of women's rights activists and women's organizations. Now, Clause 11 again seeks to extend the provision for the party list women members of the National Assembly by another 2 extra parliaments, from 2 to 4. Members of the public argued that the proportional representation system had served to disadvantage women. The women have no constituencies. I think MacDonald mentioned this. Your comment on this proposed Clause 11 amendment, and also the views expressed by the public.
Yes, looking at the views that were expressed by the public, we do agree with the public. Remember, the quota system came in as a temporal measure. And after looking at whether it was efficient, whether we won in terms of the quota system, we discovered that we didn't win anything. Instead, we experienced less women participating in leadership positions, be it politically or otherwise. So now we have a quota system that does not speak about the 1,958 seats in local government. We have a quota system that does not speak to 210 seats in the National Assembly. We have a quota system that does not talk about National Council of Chiefs. I think we need to be having conversations as to how do we achieve 50-50 as we narrow down
a whole gamut of governments.
Yes.
Because you're right. I mean, people always focus on parliament, but there are local councils, rural district councils.
Yes.
There's all sorts of different arms of government where the 50% is not actually being implemented.
True to that. And when we look at the provisions that are already there in the Constitution, we have Section 17, Section 56, and Section 80. They all speak to gender equality, that we should have equal representation in all spheres.
Okay.
So,
I'm going to have to take a breather, but I'm going to come back to you straight after the breather because I think you haven't finished explaining yet, and I have a couple of questions for you. We'll have to take a short breather now. If you have any comments or views on our show this morning, please contact us via our Facebook page, Zim Papers TV Network, or via our Twitter handle @ZTN News. You're watching a discussion on Constitutional Amendment Number 2 bill. This broadcast is brought to you by Zim Papers TV Network, ZTN, and our partners, the Southern Africa Parliamentary Support Trust, SAPS, and the European Union. Now, in our next segment, we continue to interrogate views expressed by members of the public in relation to provisions in the Constitutional Amendment Number 2 bill, particularly with regards to the women and youth quota system, and what about the amendment to the clause which currently states that running mates who are vice presidents must be elected at the same time as the president. Don't go away, we will be right back.
Life will never be the same again.
Absolutely. How to tell someone in Bari or in Soweto that they should exercise social distancing?
Every single one of us, barring a few, are praying more.
What is the health economic cost of what we are trying to achieve?
I don't know whether his chairman knows he runs at about 9 in the morning.
Yeah, I've just got symptoms, so I just called the doctor and I just then he just advised me to have to stay at home, eh?
Welcome back to a discussion on Constitutional Amendment Number 2 bill. This broadcast is brought to you by Zim Papers TV Network, ZTN, and our partners, the Southern Africa Parliamentary Support Trust, SAPS, and the European Union. Now, Sipati, before the breather, I had to cut you off, but I'd like to continue your thoughts on that. But I want you to also look at this. Now, a suggestion was proffered in the report by members of the public again for ZEC, Zimbabwe Election Commission, through subsidiary legislation, to introduce provisions to compel political parties to ensure that women be given equal opportunities to participate in electoral processes. It was also noted that the disability quota should also be included in this legislation. But I also want to draw your attention to some of the following clauses. Section 13, the state must promote the full participation of women in all spheres of the Zimbabwean society on the basis of equality with men. Section 56, women and men have the right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. Section 80, every woman has a full and equal dignity of the person with men. This includes equal opportunities in political, economic, and social activities. Now, it strikes me that these are wishes. Everyone conforms to them. Everyone agrees with them. But I suppose the issue is how can they be implemented in practice? So really, that's the first question. And secondly, what about your comments on what the members of the public suggested in terms of subsidiary legislation to make this actually effective? Can legislation effectively bring such changes?
Yes, it can. Let's look at the Zimbabwe electoral system itself. It needs an overhaul, a serious overhaul, because it's an old act that has been amended time and again. It keeps on being amended, but those amendments do not reflect the contemporary Zimbabwe. Instead, it's still what has been happening ever since. Now, I think what we need to do is look at how we want it done. We looked at the issues of representation, the diversity, the inclusion. How do we make the electoral landscape, both in terms of candidates, the way they campaign, the way they receive finances, the way they are appointed into the office, and the way we can recall them, like we're looking at the recalls that are happening right now. I think the electoral act needs to include all that. And then I think we need to discuss in the electoral, we need to discuss how to get to 50-50 when dealing with these electoral amendments bill. We are not supposed to be touching the constitution, but as Philip said, we are supposed to be aligning the constitution with the electoral laws.
But critics argue as well, Sipati, that but why have a quota system at all? Surely a man and a woman, they're together, it should be on merit, it should be on deeds and actions. And so why do you think there's a need for that? And we should actually just not have a quota system at all, and people should stand, women and men, on merit only?
We want to look at the parity first. Do we have the same, are we at the same ground? Are we at the same level when it comes to standing in these leadership positions? We'll look at that men are already in all, what do you call it? Yes, they're already all in all decision-making positions. They make it so difficult for women to be part of those decision-making processes, which makes it difficult for us to have the same level with the men.
I think just finally, before I move to MacDonald and go on about youth, we're not here talking about changing the family structure. I think a lot of people seem to equate these two things. There's your family structure, your man, woman, children at home, and then of course you've got the political, economic, social spheres. There's a difference, isn't there? I mean,
yes, there is a big difference. We only speak of gender equality at work and in other leadership positions, but at home, God's order remains. The man is the head of the family, the woman is the helper. It goes on.
I'm sure there'll be lots of comments on that, so please keep your comments coming through on our Facebook page and Papers TV Network, of course, and our Twitter at ZTN News. MacDonald, some proponents for the youth quota submitted that while it was a welcome development, the number of youths should be increased to an average of 8 youths per province. This submission was informed by the fact that the majority of people, as you yourself stated, are youth. I think the number is almost 70% of our population under the age of 35. Now, those against the quota system noted that this system disempowers the youth. The youth should be voted for into parliament. You mentioned this constituency issue. And that the inclusion of youth could easily be achieved by requiring political parties to reserve a certain number of seats for youth. Your position?
Right. I think it goes back to what we were just discussing before, and it reminds me of a conversation that we had in one of the programs that we deal with youth political party wings, and we're talking about the definition of youth as per the 2013 constitution. But if you move into political parties, they define youth differently. If we are to run with political parties, from our own viewpoint, it will not safeguard the interest of young people as stipulated for within the Constitution. In the sense that, I mean, we have had instances where a youth leader of a certain political party is beyond the bracket of 35. If you ask them within their own political party, they can justify.
They can say 50 and below.
Yes, exactly. But then I think what is also more important is for us to understand also maybe, you know, the background of this issue around the quota. Because if you go to section 56 of the Constitution, it talks about equality and non-discrimination. And it empowers Parliament in instances where it is justifiable that there's been a non-discrimination, there's been a group that is marginalized. And I think for us as young people, this is something that we have been calling on Parliament for, to consider us in terms of issues of
Do you think youth should be included in discrimination as well? Like
No. Youth should be included in governance processes. We should be in Parliament, we should be in local authorities. Government should put mechanisms that allow for young people to come through, you know, and, you know, actually go through an election with funding, you know, without fear, without intimidation, and they can actually stage their campaigns and, you know, stand equally like any other political, you know, entity that is standing for the public.
What about this comment, though? I mean, I found this quite interesting. Those against the youth quota noted that this system disempowers the youth. How can a quota system or members of the public state this, in your opinion? What were they thinking? How does it disempower you if you have a quota system?
For us as young people, it is disempowering in the sense that somebody is going to nominate you. You are not choosing for yourselves as young people someone that you see with the kind of political acumen that can deliver for your constituency. It disempowers young people in the sense that we are not going through the normal political processes that any other elected official goes. In the sense that I'm just nominated, and I next thing I find myself, I'm sitting there and I'm in Parliament. And it also disempowers because the moment that you are nominated by someone, it creates an element of patronage. You'll be beholden to
that person, your sponsor.
In a way, the kind of narrative that the person then pushes as a young person in Parliament is influenced by the nominating entity or, you know, political institution within their own political party. And we are saying that as young people, we need to stand independent when we sit within Parliament.
Okay. Well, under a party system, of course, that can't happen because obviously the party rules the rules, isn't it? What the party says goes. And in fact, maybe before I get to Philip to ask him when we move on to the Vice President's clause, I'd like to explore this further. It appears as if, I mean, in your case, you're calling for a revamping, or so to speak, of possibly the youth structures within political parties to reflect the new normal or the new reality on the ground. How are they selected? And in your case as well, I assume that political parties also need to change the way they're thinking of how do they represent women? How do they pick these women? How do they select them? You know, we don't want this patronage situation or nepotism, so to speak. There's got to be on merit. So maybe let me start with you and then I'll come to you.
I think from what we are saying, you know, beyond the issue of the quota system, there are many things that young people are saying that can actually help to strengthen their representation and governance processes. I know one of our campaigns has been on youth eligibility for public office, where we are citing constitutional inconsistencies within the Constitution. For instance, at 18 I can elect somebody into public office, but I cannot stand for public office. I have to wait until I'm 21. At the same time, I have to be 40 for me to be elected into Senate, to be considered a candidate for the president, to be able to be considered as a judge in the high courts and everything. And we are saying as young people, why are we putting age caps that disenfranchise young people, but that seem to secure certain seats for the elderly generation? And then lastly, also as young people, we are saying to Parliament, we need a commission of our own. And I think sometime last year, the Parliamentary Portfolio Committee on Youth actually went around to ask and seek the inputs of young people. And we are saying this could actually be one of the ways that can strengthen our participation and representation in some of these tiers of government. Because as it is now, if I ask you to locate the representation of young people in these spaces, it is very difficult because there's nobody who's standing for us. But for the women with the Independent Women's Commission, they have somewhere to go. It is very easy for them.
Well, that's a perfect time to throw it across to Sipati. So you heard my question to MacDonald, you know, what needs to be done internally in terms of the political parties, revamping sides, you know, in terms of making your wishes, so to speak, as a women's quota effective?
We are demanding, actually, the political parties to come up with the lists that are gender, that are gender sensitive. 50 men, 50% women and 50% men. And we're also asking the parliamentarians to uphold the constitution. Most of these issues that we are discussing here, the quota system and them are administrative issues that can be addressed in the Political Parties Act. And I'm sure we have been discussing around the Political Parties Act, which will also address these gender disparities.
Okay, thank you for that. Right, Philip, let's move on a bit. Clause 9 in the Constitutional Amendment Number 2 bill seeks to dispense with a position whereby vice presidents are elected at the same time as the president. The Justice, Legal and Parliamentary Affairs Committee report states that members of the public submitted there is no need to change the current constitutional framework, which provides for a certain certainty to a high degree. Can you further explain, in your opinion, what the general view of the public was with regards to this amendment and their reasoning behind it?
Thank you very much. I think the public were informed by the history of this country. They've seen what the current position in the Constitution does and can do. At the end of the First Republic was not something that was predicted, but it reflected on the need for a provision that deals with succession in terms of the presidency. And what the clause 9 seeks to do is to maintain the status quo, where the president will appoint vice presidents who will serve at his pleasure. But what the public are saying is that let's try what the Constitution says, which is that the public will themselves elect vice presidents into office. That has not been tried. That has not been tested. We have tested the current dispensation and we know its weaknesses. So the people are saying, let's try what the Constitution is saying we must undertake.
But one of the arguments, of course, particularly given by critics, is that if you elect a vice president, in other words, he or she is elected from the voice of the people, is it not possible you create two power bases? You have the president, of course, who's elected, and the vice president is elected. So how does the president fire the vice president or vice president? Is it possible to create two power, and can that not create political confusion?
That is not possible because the Constitution determines the powers of the president and the powers of the two vice presidents. And in any event, the vice presidents do not just emerge. The president is involved in the nomination or designation of those that will contest as his vice presidents. So this issue does not arise.
Well, I mean, what brings to mind is the American system, because that's exactly what happens in America, is it not?
Yes.
But in that case, the president of the United States can basically fire his vice president under certain conditions. So the public is saying, let's stick to how we are now and not remove this clause or amend it at the moment.
Yeah.
All right, so we'll have to take a short breather. If you have any comments or views on our show today, please contact us via our Facebook page, Zim Papers TV Network, or via our Twitter handle @ZTN News. You're watching a discussion on Constitutional Amendment Number 2 bill. This broadcast is brought to you by Zim Papers TV Network, ZTN, and our partners, the Southern Africa Parliamentary Support Trust, SAPS, and the European Union. Now, in our final segment, we asked our panelists their views on the amendment that will allow the President to appoint sitting judges of the High Court and the Supreme Court to vacancies in the higher courts without subjecting them to political interview procedure. We further asked for our panelists' recommendations. Don't go away, we will be right back. Welcome back to a discussion on Constitutional Amendment Number 2 Bill. This broadcast is brought to you by Zim Papers TV Network ZTN and our partners, the Southern Africa Parliamentary Support Trust, SAPS, and the European Union. Philip, Clause 13. This will allow the President, acting on the recommendation of the Judicial Service Commission, to appoint sitting judges of the High Court and the Supreme Court to vacancies in the higher courts without subjecting them to the public interview procedure, which is currently the case. Some members of the public were the opinion that the manner of appointment of judges is central to the values of democracy, the idea of separation of powers, checks and balances in the democracy, and an efficient and independent judiciary to sustain the separation of powers. Can you explain this further?
Well, the position is that the executive should not be generally involved in around issues involving the judiciary. And the way that the Constitution was crafted was meant to ring-fence the judiciary against executive interference. And the public interview process was meant to deal with issues of transparency. People would see the candidates and see the appointment process. The executive would only be involved in the final lap, which is to get the best candidates from the interview process. But what the amendment seeks to do is to give the executive a right to appoint from recommendations by the Judicial Service Commission. The argument by the executive is that because the Judicial Service Commission supervises the judiciary anyway and therefore knows who are the best candidates. But the position is not about who is the best candidate or not. It is about the issue of the independence of the judiciary. The executive should not be involved in direct appointments, because that has been the position since independence, and the weaknesses of that have been identified. So what the Constitution sought to do was to ensure that there is a procedure that ensures that people are involved and they see the process, and that the executive do not have or do not create the impression that they can actually appoint and fire members of the judiciary.
So my question is, who appoints the Judicial Services Commission?
Well, the appointment process is in the Constitution. It also involves the executive, which is why it is critical that that transparent process where the public are involved is held, because the appointment process of the Judicial Service Commission also involves the executive. So you want a more transparent process, which is what the current constitutional provisions provide for, and which is what this amendment seeks to change.
I want to bring the other two panelists in now. If you look at the proposed amendment, I want to start with you, Sipati. The concern appears to be, coming out of the report from members of the public, is this separation of powers and the independence of the judiciary. And that's quite a vital thing in any democracy. Your comments on this?
There's no need actually to change what is provided for in the Constitution, like what Philip have said, but we need to safeguard democracy and the principle of separation of powers. The president doesn't need to be involved in this process. He's not supposed to be anywhere near that process.
Okay, right. McDonald, the same question for you, this independence of the judiciary, and also the impression, because when I was reading the report, the impression that power seems to be, in the present Constitution, power is being devolved, and in the amendment, it's going back up again. Your comments on to that?
But I think our comment on that is to say that we must uphold separation of powers and the independence of the judiciary, because the Constitution is very clear about good governance, about transparency, about participatory and representative democracy. And I think for us as citizens, we actually enjoyed it. It gave us so much confidence in our own judiciary. When they are put in a public gallery and we attend, we get to hear of them, we see them, and we get to know who is selected. But imagine a scenario where this is done behind, and then we are told that this is now your judge, this is now your... And I think if it even try to look at how in the recent months there have been attempts to sort of like manipulate judicial processes, it also even brings a lot of questions into why the executive would want to find its fingers. And it even goes back to the issue that I mentioned earlier, to say that such an amendment, in our viewpoint, it would also create patronage where the appointed judge by the executive then gives allegiance to, and not necessarily to the constitution. Yet all these people and institutions must be taking their mandate from the constitution and not from any individual that actually nominates them.
So you're talking transparent, open, public hearings that at least we can see the candidates and say, yes, this is a good candidate. In fact, confidence and trust is the issue here, is it not?
Yes,
and I mean, that's what you would also say.
I concur. I agree with him. Yeah.
All right, now, Philip, I want to move back to a question I had asked you earlier. One of the major issues expressed in the report by the public, of course, the report from the Justice, Legal and Parliamentary Affairs Committee, was the need to urgently align laws and full implementation of the Constitution rather than rush to amend the Constitution. So, if I had to talk to you as civil society, in your opinion, what actually then are you recommending? Are you recommending that we put a hold on this constitutional amendment bill? We try and see if the original 2013 Constitution is effective or not? Or are you saying that let's go forward? What are you actually recommending?
Well, I think the crux of the matter lay in the fact that the process by which we arrived at a new constitution involved people at all levels of society. The Constitutional Committee went from province to district to ward level. The current amendments are executive-led, executive-driven. They are not amendments that have been generated by the same people that wrote the Constitution. So I think that's where the problem is, that the Constitution was arrived at through a referendum where everyone voted and they said this is what we wanted and this is what we have. And before we have implemented it, we are already tinkering with it. And that's what the majority of the people were saying at public hearings conducted by Parliament.
But again, the conclusion of the report from the Parliamentary Committee is that as even though members of the public had these comments, they generally felt that the amendment should proceed. So the question is, you talk about citizen participation, but surely that means that there must be some good ideas coming from citizens that should at least change the minds or change the drafting of the amendment. But it appears that none of those ideas were taken up. Or am I incorrect in that?
Well, I think it goes to the question of the implementation of Section 141 of the Constitution, which deals with public engagement. There's a Constitutional Court decision on the fact that parliamentary engagement is not just a procedure or a practice that should be done as a matter of practice, but that public contributions must actually matter and be taken up. And I think that probably Parliament will need to look at the implementation of Section 141 in terms of how do they ensure that the majority view takes precedence in parliamentary recommendations.
Because if you have a process whereby you do have public participation meetings, and you listen and you spend a lot of money on them and you go around the country and then you come back to Harare and basically just continue with how you started in the first place. That sort of defeats the whole purpose of it, does it not? Anyway, right. Sipati, I want to ask you about your recommendations. The report states that while extending the women's quota system in Parliament is a progressive idea, it perpetuates a pretense of promoting women's participation in politics when the government should be implementing, as you yourself said, already they should be implementing the 50-50 equal representation as required by the Constitution already. So your recommendations, are you happy with the amendments as they stand? Or if you aren't, what would you like changed in there?
We're not happy at all. People spoke during the consultative processes. They said no to quota system. So if this quota system is to go ahead, whose interest are you serving?
Hang on, they said no to a quota system.
Yes.
They said abolish it.
They said no to quota system.
So they didn't want 50-50 at all. They said implement what's there now.
In the Constitution.
I'm with
Yes.
you. Okay, all right. So your recommendations are let's implement the existing Constitution. Please tell me in your own words. What would you say?
I would say implement the Constitution, align the electoral laws to the Constitution to achieve 50-50.
But then bring in, as you said earlier, bring in these issues covering councils, etc., etc. In other words, put laws in place, legislation frameworks in place to cover the quota system all the way through government.
Oh, yes.
Okay, MacDonald, same question to you. The recommendation, the principles of the bill, are you happy with the provisions as they relate to youth?
All right, we are not happy. We feel that we need more as young people. We seriously need at least 8 PR seats per province. And the question that you posed reminds me of one of the key questions that we asked in the public hearings, to say, where did the amendments originate from? And I think already Philip has talked to say that it originated from the executive. And I think in future we need the kind of executive that also takes time to listen to citizens, because various entities, citizens, civil society, trade unions, in different ways they engage Parliament. There is a need for our executive to listen in such a way that if it engages in a broad process like that, they engage citizens. And I think the last thing that I might also need to give emphasis to is that if you look at from 2013, this is the first time that the Constitution is going through several amendments that change the taste and the nature of the Constitution. And some of the thinking that was within citizens is to subject the entire process to a referendum.
Well, that's another thought, isn't it? I'm not sure that will happen, but it's an opinion. Philip, finally, the Justice, Legal and Parliamentary Affairs Committee report noted, and these are two critical issues. The majority of people who attended the public hearings, including those who contributed in writing, did not comprehend the doctrine of separation of powers, independence of the judiciary, and attendant issues, and called for more effort by relevant stakeholders to sensitize the public on the content and import of bills before embarking on public hearings. In other words, they didn't really know what was going on, effectively. I think that's what it's saying. And also the second point, which I think is relevant to all of the organizations, is it was observed there were members of civic society organizations who were moving from venue to venue, replaying the same points and advancing the same arguments, thereby making it difficult to conclude whether these were general views or influence views. So those are two critical issues. Your comments on this?
Okay, I'll start with the last one. Well, I think most organizations in civil society in Zimbabwe are networks, and therefore you'll find that the same voice that is made in Harare will be repeated elsewhere because of the networks. It's the same with political parties. Political party A will say the same thing in Harare, Bulawayo, Mutare, and so on, and it doesn't cause any concern to parliamentary committees, because that's what the political party wants. And the same applies to the voice of civil society. There are networks, and most of them, like my colleague here, belongs to a national association. So Nayo in Harare will say the same thing in Mutare and so on. So that's a non-issue.
With 5,000 civil society organizations, it
Yeah.
can create a lot of confusion.
Oh yeah,
Let's be honest.
So that issue, I think, does not arise. Then the first issue
Separation of powers, the
Yes.
sensitization of the public.
Oh, yeah.
Because you can go having this huge bill amendments, but if I don't understand it,
Yeah, I think if you go to Section 7 of the Constitution, it says the state bears a responsibility of public awareness of the Constitution. That obligation has not been substantially discharged by the state, and the parliamentary committee observed that. So the state still bears the responsibility of ensuring that the people know the Constitution. If everyone knew this Constitution, probably the voice of the people would have been actually louder. In some countries, they'll make sure that the smallest child who goes to primary school will have access to the Constitution in their indigenous language, so that they know
so
what
teach it from when they're
Yes.
growing up, so
Oh,
that
yeah.
by the time you get to be an adult,
they
you're
know
fully aware
everything.
of their
Yes,
rights.
so the state and other stakeholders, should continue to ensure that people know about the Constitution.
All right,
And-
we have to end it there. As I always say to my panelists, we could talk for hours about this because it is such a critical issue and something that should concern all Zimbabwean citizens. We have come to the end of our program this morning. You've been watching a discussion on Constitutional Amendment Number 2 bill. We'd like to thank our panelists: Philip Mudziri, Southern Africa Parliamentary Support Trust, SAP's Programs Advisor; MacDonald Munyoro, Programs Manager, National Association of Youth Organizations; Nayo Sepati Moyo, Chairperson Politics and Decision Making Cluster at the Women's Coalition of Zimbabwe, WICOS. Ladies and gentlemen, thank you so much for a great and vibrant debate.
Thank you
Thank
very much.
you.
This broadcast is brought to you by Zim Papers TV Network ZTN and our partners, the Southern Africa Parliamentary Support Trust, SAPS, and the European Union. All that's left for me to say this morning is, I'm Andy Hodges. Have a great day. Goodbye, and you all be safe.